Okay. Good afternoon, ladies and gentlemen. Today's class will continue on the last discussion about a criminal defense. And I also like to introduce the elements of various crimes in the last of this class. Okay. Let's see. As I have adduced, competence to stand trial is a threshold issue to continue the court proceedings. But the standard should be different, that the criminal one is serious to require the status of more sanity on the defendant case. But what if the defendant has no probability to recover his competency? Is it permissible to subject him to virtually permanent institutionalization, waiting if he would be medically determined to be capable of standing to trial? The Supreme Court denies such kind of arrangement based on the due process concept. Therefore, in the case that there would be no substantial probability to attain a competency, the defendant must be released. Of course, the civil proceedings could be still unaffected to continue. This context was disputed in the case of Jackson versus Indiana, decided in 1972. In this case, Jackson, a defendant of this case, a mentally deficient deaf mute with almost no communication skills, was accused of 2 robberies involving a total of less than $10. After the defendant pled not guilty, the court ordered competency examination to determine his ability to stand trial. One doctor testified that this prognosis appears rather dim. The other doctor saw the defendant would never develop the necessary communication skills to stand trial. The trial court found that the defendant lacked comprehension sufficient to make his defense and ordered him committed until the Indiana Department of Mental Health certified to the court the defendant was sane. This counsel moved for new trial, arguing that there was no evidence the defendant was insane and that committing him amounted to life sentence in violation of the 14th Amendment rights to due process and equal protection and constituted cruel and unusual punishment under the 8th Amendment. The trial court denied the motion. The Indiana Supreme Court affirmed. Rehearing was denied, and the certiorari was granted to be referred to the Supreme Court of the United States. In this case, the issue would be if a state can constitutionally commit a defendant to a mental hospital for an indefinite time only because he is not competent to stand trial on the charges against him. The court held negatively, and the commitment order is reversed and the case was remanded. The court considered 2 prongs of test about equal protection and a due process. Under the criminal commitment statute, the state needed only to show defendant's inability to stand trial. Under the civil commitment statute, the state needed to show either mental illness or that the individual is in need of care, treatment, training, or detention. Thus, different standard exists. And it is unclear that the state could meet its burden under the 4th test since the doctors did not address the issue. The The record also fails to establish the defendant was in need of custodial care or detention. In fact, evidence pointing to the opposite conclusion. The standards for release are also different. Under the civil statute, defendant would be released when he could take care of himself. Under this standard, he might be released at any time. Under the criminal statute, however, he would not be released absent an unlikely change in his condition. There is no rational distinction between a person charged with a crime and a person already convicted of crime. Where this court held that a person in prison could not be committed for further mental health treatment without a proper procedure. And the court went on, by subjecting defendant to a more lenient commitment standard and a more stringent release standard than those generally applicable to those not charged with offenses, and thus condemning him in effect to permanent institutionalization with the showing required, or the opportunity for release provided by the other two standards, the state deprived defendant of his equal protecting rights. A long sentence to vindicate. And the court said, on the point of a due process concept, at a minimum, due process requires that the nature and duration of commitment bear some reasonable relation to the purpose for which the individual is committed. Initially, a person committed solely because he is incapable of standing in trial can be held only long enough to determine if there is a substantial probability that he will attain the capacity in the foreseeable future. If that cannot be established, the defendant must be released, or civil proceedings must be started. Any continued commitment must be justified by progress towards the goal of competency to stand trial. Here, defendant had been confined 3.5 years with no evidence he would ever be able to participate fully in a trial. Okay, in a comparative viewpoint, the Korean Criminal Procedure Act also strictly requires the presence of defendants in the proceedings. It prescribes the right of defendant to attend the proceedings, which forbids a continuation of proceeding in case of his absence. There is an exception where it could go without a defendant's presence. The court provides that there would be permissible in the trial less than 1 million fines. The court also offers a various statutory ground. The defendant absence trial can be initiated and continued. So see, if the defendant refused to attend the trial without any justifiable cause, but also could not be made present by a detention officer, the court can continue the proceedings. In this case, however, the judge has to obtain a counsel from the prosecution and defending attorney. As of the nature of civil suit, it is basically structured to rely on the representing counsel. Therefore, it is far insignificant to view the party's presence as essential. This is also true in the Korean civil law. And we now overview an insanity defense. A defendant may not be held criminally liable if at the time of the crime he was impaired by mental disease or defect as to be insane within the meaning of the law. The notion of insanity refers to defendant's inability to engage in morally reprehensible behavior or to understand what he or she is doing. It differs from diminished capacity, which may be used as a defense to the element of a mens rea. The distinction between this defense and other one is of common origin indeed. In civil countries, the law deals with a more broad concept of lack of a responsibility or diminished responsibility. The criminal code in Korea, one of civil law provisions, provides also a two classes of a criminal responsibility. A lower degree for diminution of criminal penalty and higher degree for entire exemption from a criminal liability. Given the three dimensions of crime in general theory of Korea, this argument is considered to fall within the last step of review. To say, the court forced to review if the act satisfies the factual elements of each criminal provision, and secondly observes the act of defendant in view of a social and objective evaluation. The rule on actus reus and mens rea reviewed in the last class will apply to the fourth step of review. The second step review requires an objective assessment of the act itself. And lastly, the court has to look into a subject condition of the criminal himself. In this last step, two broad concepts gives a criterion to a judge. Of course, this separation is just theoretical, and in some cases, different elements overlap in the process of review. You may feel the common law approach seemed a little practical, covering insanity, drug addiction, and alcoholism, and diminished capacity, while the civil law jurisdiction could be seen rather to rely on the general conceptualization. The defense of insanity, however, shares a common trait. While the various formulations of the insanity test differ significantly, all require that the defendant has some sort of psychological impairment. However, not all impairments will give rise to insanity. Fourthly, a mental retardation. Mental retardation or feeble-mindedness can, if it satisfies the applicable test, to render the defendant legally insane. And next, intoxication. Intoxication is ordinarily the subject of a separate defense, but may, in certain cases, also be relevant to insanity. Regardless of impact on the defendant's mind, mere voluntary intoxication does not raise an issue of insanity. Involuntary intoxication, on the other hand, is treated as though it were a mental illness and can, if it produced the required effect on the defendant's mind, support the insanity defense. In addition, insanity may also be caused by repeated use of intoxicating substances, where, because of such uses, the defendant has developed reasonably settled physical or psychological abnormality. And in previous times, the psychopath was treated in criminal terms. Although so-called psychopaths are sometimes regarded as morally insane, many courts exclude this condition from the insanity defense. For instance, the Model Penal Code specifically provides that mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. This was intended to prevent persons diagnosed as psychopaths from being acquitted by reason of insanity. Some courts have held that even if the model penal code's definition of mental disease or defect is controlling, a diagnosis of the defendant as psychopathic will not automatically preclude the insanity defense. Even under this view, however, a claim of insanity cannot be supported simply by evidence that the defendant has committed numerous crimes. And in the United States jurisdiction, tests for insanity have been developed in a four prongs. There is considerable disagreement as to what standard should be used to determine whether a mental disorder has sufficient effect on the defendant to render him legally insane. As will be seen, several different tests are currently recognized. The traditional standard still used in many American jurisdictions is the so-called a Magneton rule. Under the Magneton test, a defendant is to be acquitted by reason of insanity only if in the time of committing of the act he was laboring under such a defect of reason from disease or from disease of the mind as not to know the nature and quality of the act he was doing, or if he did know that he did not know he was doing what was wrong. Instead, more simply, a defendant must show that as a result of his mental illness, he either did not know the nature and quality of his act or did not know that the act was wrong. In Magneton case, decided 1843, which is considered the landmark case about this test, Magneton shot and killed a Drummond while under an insane delusion that he was instead killing his persecutors. The trial court found a defendant not guilty by reason of insanity, specifically finding that defendant could not, because of his delusion, have killed willfully. The court held the cognitive ability of defendant to determine right from wrong should be the basis of legal insanity. The jury should be instructed to presume the defendant is sane. Insanity may be used as defense to criminal actions only if it is clearly proven that at the time of committing the criminal act, the party was laboring under such a defect of reason from disease of the mind as not to know the nature and quality of that he was doing, or if he did know it, that he did not know he was doing what was wrong. If the defendant labors under delusion as to fact and the facts, if they were as he supposed them to be, or to support the excuse of his acts, the defendant is not responsible for his acts. Medical experts may be used if they testify only as to matters within their expert knowledge, as long as testimony is limited to scientific questions or matters not in dispute or admitted. This Magneton rule is the origin of insanity defense rules. Since its adoption, other rules have been adopted either to broaden the scope of the insanity the defendant must be under, or to change the scope of the rule so that the ability to form criminal intent becomes the critical factor. English courts define wrong to mean legally wrong. Thus, one who, because of mental illness, believed his act to be morally permissible, but still knew the law would regard it as wrong, is not entitled to acquittal. American courts, however, have differed, some adopting the English view and others holding that the defense is established if the defendant did not know his act was morally wrong. Most jurisdictions hold that the defendant does not know the nature and quality of his act if it does not understand its physical nature and consequences. A minority of courts, however, require a showing that the defendant, by reason of his mental illness, lacks a true insight into the nature of his conduct. Under most applications of Manhattan law, the defendant's ability or inability to control his behavior is not irrelevant. It is true the Manhattan test has long been the subject of much attack. So it is fairly considered to be outdated in modern criminal jurisdiction, but offers the starting point about the test of insanity. In some states, the defendant is entitled to acquittal if a commission of the crime was caused by an impulse which controls her will. This is called the irresistible impulse rule. The irresistible impulse test is generally adopted as an alternative to the Manhattan law. The accused will be deemed legally insane if she either could not control the urge to act as she did, or did not know what she was doing, or that it was wrong. The irresistible impulse rule has often been criticized on the ground that it requires a certain loss of control and therefore makes the insanity defense unavailable to one whose loss of control is the result of a long-standing illness. But this criticism is based on a misunderstanding of the law. The irresistible impulse rule is not limited to impulsive acts, and so does not require a certain loss of control. And thirdly, we can illustrate Durham rule. It is called a product rule and very simple in understanding the Gestalt test. It is third a formulation of the insanity defense, and it is called, under which a defendant is entitled to acquittal by reason of insanity if the evidence shows that his crime was the product of a mental illness. In modern penal code, it was deemed marshaled from the previous two occasions. Let's see. The modern penal code test is gaining in popularity and has been accepted by most courts and legislatures that have recently reconsidered the proper formulation of the insanity defense. With the modern penal code approach, a defendant is entitled to acquittal by reason of insanity if the evidence shows that because of a mental disease or defect, he or she either lacked substantial capacity to appreciate the criminality of his or conduct, or lacked substantial capacity to conform his or conduct to the requirement of law. The test requires only that the defendant has lost the substantial capacity to appreciate the criminality of his behavior or to control it. Hence, unlike the Manhattan and irresistible impulse rule, a total impairment of cognitive capacity or capacity for self-control will not be shown. This test was actually esteemed in many ways, but also encountered heavy criticism let's see, some commentators have criticized the model penal code test for its use of the ambiguous terms, a substantial capacity, and appreciate. But the major criticism concerns the volitional impairment part of the test. The defendant's ability to resist the desire to commit an offense. Resolving this issue may well be an impossible task, and so perhaps it should not be undertaken by the law at all. And there is a plain rule that requires a sense of justice test. This test is very simple and has a universal character to humanity, let's see. Arguments have also been advanced that the law should not attempt a precise formulation as to when an accused should be acquitted by reason of insanity. Rather, some authorities urge that the matter be left to the discretion of the trial judge. The theory behind this approach is that the decision to exempt an abnormal defendant from liability involves complex ethical social issues which turn upon matters much broader than the ability to control one's conduct. Therefore, it is argued the jury should be encouraged to consider all relevant information. And finally, we can see a modern federal approach. After John Hinckley was found not guilty by reason of insanity of attempting to assassinate President Reagan, a widespread movement to abandon the volitional impairment aspect of insanity culminated in the adoption of 18 U.S.C. Section 20. This section recognized the insanity defense for federal offenses only when the defendant, as a result of a severe mental disease or defect, was unable to appreciate the nature and quality of the wrongfulness of his acts. This eliminates the volitional aspect of the insanity defense. Section 20 also places on the defendant the burden of proof by clear and convincing evidence. And the case, titled United States v. Broner, decided in 1972, dealt with the ARI test, American Law Institution test. In this case, Broner, a defendant, appeals a conviction of second-degree murder and for carrying a dangerous weapon. Defendant's defense is insanity. The court previously followed the Durham test. The court switched from the previous position that the Durham test may not be controlling for insanity defense. And the jury, in the court order, the jury should be instructed according to the ARI standard. Durham was adopted to allow experts to testify in their own terms and not according to legal moral terms, or right versus wrong test. Also, it was to reflect the fact the result should be reached according to current community standards of culpability. The test has some problems. The word product has meant the undue influence has been given by the jury to expert testimony. In effect, experts giving their medical opinions have dominated the issue. This does not reflect the fact that the defense is based on legal, moral, ethical, and other bases which are represented in the jury. The ARI test provides that a person is not responsible for his unlawful conduct if, at the time the conduct occurred as the result of mental disease or defect, he lacked the capacity to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law. A mental disease or defect includes any abnormal condition of mind that substantially affects mental or emotional processes and substantially impairs control. This standard allows expert testimony, but it is in language understood by all those involved with the judicial process, and this leaves the issue ultimately to jury, where it belongs. The concurring opinion pointed out the ALI test still emphasizes the causality element. It is just shuffling words around. The real issue is how the defense is presented to the jury, because in the last analysis, the issue is a jury issue. There are two elements that should be emphasized: an evaluation of the mental or emotional impairment, and an evaluation of the blameworthiness of the person's conduct in light of community standards, considering the person's level of impairment. Thus, the proper test is to acknowledge to jury that it must decide based on its collective common sense. The following instruction would accomplish this. And the concurring opinion actually paragraphed the jury instruction in this case. Let's see. Defendant is not responsible if at the time of his unlawful conduct, his mental or emotional processes or behavior controls were so impaired that he could not justly be held responsible for his act. Do you think a correctly paragraph to reflect the correct rule of law? Now, we like to see several aspects of procedure involving insanity defense. There are many reasons why a defendant might choose not to plead insanity as a defense, including the expense of hiring psychiatric experts and the prospects of indefinite commitment should the plea prove successful. Does the accused have the right not to plead insanity? This issue was disputed in the case State versus Jones, decided in 1983. Jones was charged with second-degree assault while armed with a firearm. The court ordered an inquiry into defendant's competence to stand trial. Jones was defendant in this case, which resulted in a finding that he was competent. However, the court granted a prosecution motion to enter a plea of not guilty by reason of insanity over a defendant's objections, because it concluded that there was a strong possibility that he had a valid insanity defense and he would be convicted if he were not asserted. He was found not guilty plea and committed to a mental institution. The state Supreme Court granted a review. The state Supreme Court held a court must not enter a plea of NGI over the objection of the accused, and the lower court judgment was reversed. The Supreme Court has emphasized the constitutional right of a defendant to broadly control his own defense. Accordingly, a court should not force any defense on a defendant. The rights to plead guilty and to control one's defense are not absolute, however. Before relinquishing any rights or controlling his own defense, the accused must be made aware of the dangers and disadvantages of his decision, so that his choices are made knowingly and intelligently. The competence standards for waiver of the insanity defense and for standing trial are the same. When a defendant wants to waive his insanity defense, the court may only inquire whether he is competent to stand trial and whether his decision is intelligent and voluntary. And we need to know the rule on burden of proof about the insanity defense also. In all jurisdictions, there is a general presumption of insanity, and hence the defendant has the initial burden of going forward with the evidence. The insanity issue is not raised until the defendant presents some evidence tending to show that he was insane at the time of the defense. The states differ, however, as to the allocation of the burden of proof once the accused has met his burden of going forward with the evidence. As you know, the burden of going forward with the evidence is an initial step about the conclusion to the final facts in the court process. And procedures exist in all states for the commitment to mental institution of a defendant found not guilty by reason of insanity. But these processes differ and in certain cases may be subject to constitutional attack. There would be three kinds of commitment in terms of commitment in this context. First, there's a mandatory commitment. In some jurisdictions, a defendant acquitted on insanity grounds must be committed for a treatment. Commitment follows automatically, and the court has no authority to inquire into the defendant's present condition. In other states, commitment is discretionary with the trial judge, so that a defendant is committed after acquittal only if it is established that he is presently mentally ill and dangerous. In addition, some courts require that these commitment proceedings afford the defendant all of the procedural rights and protections available to persons for whom civil commitment is sought. Usually, persons committed to mental hospital may be released only upon order of the committing court or some other judicial body. Generally, one or four or a different standard is invoked to determine whether a release is appropriate, whether the person is not dangerous, whether he is sane, whether he is either sane or not dangerous, and whether he is both sane and not dangerous. The model penal code adopts the first standard, requiring only a showing of not dangerous. The burden is usually put upon the former defendant to prove that he meets the applicable standard for release. Recently, proposals have been advanced to abolish the insanity defense entirely. A number of authorities would eliminate mental illness defenses, but permit evidence of mental illness to be considered in determining what, if any, a penalty to impose after conviction. Some states permit the jury to make an intermediate finding of guilty but mentally ill, ensuring that the defendant will be imprisoned for the balance of his sentence after treatment. Others would admit proof of mental illness at trial, but only for purposes of demonstrating that the accused lacked the intent required for the crime. The next common law defense may be diminished capacity, which could be seen as intimate with the civil law concept. But it is unlikely the common law jurors patronize this formulation and possibly go overboard in some cases without a substantial element of concept. The vagueness of practical criterion would likely to work. The pragmatism and problem-solving approach in the tradition of intelligence seem generally require more practical dealings. In contrast, the continental tradition in Europe is considered to slant on a system-building approach. Do you agree if this contrast fostered a separate path of legal evolution? And we have the defense of influence available in the common law context, and that defense is also available in a civil law jurisdiction. Generally, the defendant's age in criminal law is strictly enforced, notwithstanding the actual mental capacity of minor offenders. That is because the criminal law's preeminent vision is to ensure legal stability of people, thereby protecting a citizen from potentially arbitrary use of criminal powers. In this context, the Korean court sets forth a defendant age at 14, where he or she below this age must be acquitted from ground of infancy. The legislative powers is generally held in vast of criminal jurisdiction. But we may find a modified form of dealing in the cases like a state versus a Q&D. This case dealt with the presumption of incapacity. In this case, Washington had a statutory conclusive presumption of incapacity through age 7 and rebuttable presumptions of incapacity between ages 8 through 11. And a QD was defendant in this case and was 11 half years old at the time, was caught on school grounds with the custodian's keys. He was taken to the principal's office and left a stolen burglar alarm behind the chair he was sitting in. The defendant was charged with first-degree trespass. In this case, the court held the presumption of infant incapacity applies to juvenile adjudication. So you may find some various forms of a statute in the defense of infancy. I forgone the, sorry. I would now like to show a picture of Michael Jackson, and I'd like to introduce the elements of various crimes that will be discussed in the next class. You see, Michael Jackson. One time, we were shocked at the sudden death of pop star Michael Jackson. He was a really gifted artist, a long time, attracting the global public. We were once again appended with exposure to the striking title of article. Michael Jackson was killed. Is it correct? Then we tried our guess on the myth of his death, but we soon get to know the story was built on his long addiction to drug and the potential miscarriage of his committed doctor. There might be some long business relationship with Michael Jackson, which might force the doctor hard to refuse his client's request for more drugs. It is very paradoxical that the drug was now much patronized by some Korean lower class in some unusual way. The drug was known to be so addictive to induce easily an intoxicated physical condition. Then some of us might feel misled by the article's word of internet. The article of Korean version used the word kill or murder, which could have been correctly indicated by the term homicide. In that context, okay, I'll get shown. In that context, we will, in the next class, overview a diverse class of common law murder. And in the Korean illustration, the story of that drug would go to the voluntary manslaughter in some cases, or intoxication defense discussed earlier in this class. Okay, I now stop here, and that'll be all for this class. See you in the next class.